right, it is me. Next, Sri Kolikonda Sharad Babu. And next, Miss Motamari Sri Vidya. So your feedback about our PG-Last 22 online virtual class is immense value. Virtual help to us to improve our virtual classes. Please send in WhatsApp your opinion, comments, views without any fear and favor. We are very much thankful plus indebted to you all the participants for your observation, and your observation make us to streamline our defects, and we are going to deliver the good thing in future. So with this, I would like to turn out to the ladies first. As I said, Motamari Sri Vidya, now switch over to her. You can start now.
Yes, sir. Good evening, all. We'll start with IT Act. Information Technology Act 2000 is Act number of dash of 2000. Option A 35.
Oh,
Option B
sorry,
20.
that no, this is not that you are. I have to post the other thing because it's a mixed one. So
Yes, sir.
yeah, it's a
Regarding
mixed
IT.
one. Yeah, no, just no, it is here. It is here. Mixed SVMS. Okay, yes. But you are reading.
I thought you just changed it for me and Sharad Babu.
Yes, this is the host. Yes, this is the mixed one. Yeah, now we can start it. Yes.
Good evening, sir.
Good evening.
And thanks a lot for your all time, sir. Means the way you have taught us the things are so good. It will remain forever in our minds, sir.
I
Hope it will do
appreciate.
well
You
in
send
our...
the same thing in the WhatsApp. Two individuals, which I made the screenshot. If you want, you can take the screenshot also. And there,
Yes,
we
sir.
have
Sure,
our
sir.
own WhatsApp number. You can take the
Sure, sir. Sure,
screenshot.
sir. This one, sir. Yeah.
Okay. Now, yes, Matamari, you can continue with the mixed multiple choice question. Right. Number one.
The motive under Section 81 of IPC should be Option A, prevention of harm to person. Option B, prevention of harm to property. Option C, both A and B. Option D, either A or B.
Option C, both A and B.
IPC is regarding both harm to person and property. Yes.
Yeah.
Second question. Section 82 of IPC enumerates option A presumption of facts, option B, rebutable presumption of law, option C, conclusive or irrefutable presumption of law, option D, none of the above.
Presumption of fact. Act. Option A.
Yes, option A is the correct answer.
Just a minute. The first question is concerned. The right answer is D. The right answer is D. Reason is it may be the harm to the person or harm to the property also. Both the way. Either this one or that one or both also. What do you say?
Okay, okay.
Host.
Yes, sir. Tricky question, sir. Tricky options.
Prevention of harm to person. Yes, it is trespass to person. Prevention of harm to the property. Yes, it is trespass to land and trespass to property. And both A and B, either A and or B. Either both the way it may be possible. So the preferably the right answer is D. Is it clear?
Okay. Yes, sir. Either A or B.
Yes, yes. Next, you can proceed.
Section 82 of the third question, sir.
Proceed.
Yeah, you read third question.
The maxim actus non facit re nisi mens sit rea means option A, crime has to be coupled with guilty mind. Option B, there can be no crime without a guilty mind. Option C, crime is a result of guilty mind. Option D, criminal minds lead to crime.
Option B, there can be no crime without a guilty mind.
You're right.
Yeah.
Next.
Fourth question, which of the following is correct for the aforesaid? First one, the physical accept of crime is accept actus reus. Second, the mental accept of crime is mens rea. Third one, the motive of desire to commit crime. Option A, 1 and 2 are correct, but 3 is not correct. Option B, only 2 and 3. Option C, only 2 and 3. I think it's repeated, sir. Option D, all of the above.
Oh, no matter, no matter.
Yes, sir. Means option A, sir. A and 1 and 2.
Option D is the correct answer. Option D is the correct answer. All the above.
The host should have to say.
Yes, sir. Yes. The motive is the desire to commit crime. Okay.
All the
Then,
three options are correct.
Sir, all the above are correct, sir.
D. All
Yes,
the
D
above.
is the correct answer for the fifth question. Next.
Fifth question, a hangman who hangs the prisoner pursuant to the order of the court is exempt from the criminal liability by virtue of option A, section 77 of IPC, option C, section 79 of IPC, option D, section 76 of IPC.
Option B, sir. Section 78 of IPC.
Yes, correct answer. The next question, the person making the proposal is called, the person accepting the proposal is called. Option A, proposer, proposee. Option B, promisee, promiser. Option C, promiser, promisee. Option D, proposee, proposer.
Sir, option C, sir. Promiser and promisee.
Yes. The person who is giving is called promiser and who is taking is called promisee.
Promisee, yeah.
Seventh question, every promise and every set of promises forming the consideration for each other is called. Option A, a valid, avoidable contract. Option B, a contract. Option C, a void contract. Option D, an agreement.
Yes, sir. Means promises forming the consideration for each other is called an agreement. Option D.
Agreement with consideration is a valid agreement.
Yeah.
Eighth question, the Indian Contract Act 1872 extend to. Option A, the state of Jammu and Kashmir. Option B, the Union Territories of India. Option C, the whole of India except the state of Jammu and Kashmir. Option D, the whole of India.
Option D, the whole of India.
Yes, extend to whole of India. Where we got Jammu and Kashmir Reconciliation Act, from that it's applicable to whole of India.
Yes.
The ninth question, the act which deals with the matters relating to the contracts is titled as. Option A, the Contract Act 1872, the Indian Contract Act 1872, the Indian Contract Act 1882, the Indian Contract Act 1972.
Option B, the Indian Contract Act 1872.
Yes, correct answer. 10th question, an agreement not enforceable by law is said to be. Option A, a contract. Option B, a void. Option C, a voidable contract. Option D, a void contract.
Void contract. Option D.
Yeah, it's nothing but void contract. It may be sometimes option B or option D.
Yeah, the most appropriate is void contract.
11th question, Information Technology Act 2000 came into force on. Option A, 1st January 2001. Option B, 11th June 2000. Option C, 17th October 2000. Option D, 24th December 2002.
Option C, 17th October 2000.
Yes. Section 66A of IT Act 2000 has been struck down with a Supreme Court order dated 24th March 2015, in which case? Option A, Shreya Shingil vs. Union of India. Option B, Puttuswamy vs. Union of India. Option C, Shaira Banu vs. Union of India. Option D, Indira Swahani vs. and Union of India. Which was
Option A.
Option A.
Shreya.
Yes.
yes.
It is a sure question which may be asked either for the section or for the case.
Yes, sir.
Even they can ask the who is the judge has given the judgment,
Yes.
including the year. That's the date and month and year.
But we don't know the judge's name.
We cannot remember, so there is a problem.
No, because I told you in a technique. Automatically your sixth sense go and strike it because the software is developed in a such a way.
Yes, sir.
Read. 13th.
What is this Swami vs. Union of India case? We already discussed in the previous class.
Okay. 14th.
1 minute, sir. The 13th question. What is the punishment in India for stealing assets or any software source uh, code from any organization, individuals, or from any other means? Option is 6 months of imprisonment and a fine of rupees 50,000. Option B, 1 year of imprisonment and a fine of rupees 100,000. Option C, 2 years of punishment and a fine of rupees 250,000. Option D, 3 years of punishment and a fine of rupees 5 lakhs.
Option D, sir. 3 years of imprisonment
And a fine of
and
rupees. Yes.
fine of 5 lakhs. Yeah.
Next question 14th. Appeal can be made to High Court against the order of appellate tribunal within dash days.
30
Option
days.
no. Option B 60 days. Option C 45 days, and option D 90 days.
Yeah,
Again,
within 30 days.
D 90 days, sir.
no, it's 60 days.
The B is the right answer.
Yes, yes. 15th
Okay.
question. When the conciliator receives factual information concerning the dispute from a party. Option A, he shall disclose the substance of that information to the other party. Option B, he shall not disclose substance of that information to the other party. Option C, he shall or shall not disclose substance of that information to the other party. Depends upon his discretion. Option D, none of the above.
Option C.
No, he shall disclose substance of the information to the other party.
Okay.
16th question. The 15th answer is option A. 16th question. As regards the determination of rules of procedure, the arbitral tribunal shall not be bounded by option A, the Indian Evidence Act 1872, Act number 1 of 1872, the Code of Civil option B, the Code of Civil Procedure 1908, Act number 5 of 1908, option C, A or B both, option D, none of the above.
C.
Option D.
Yes, none of the above is the correct answer.
So the next host is our, yes, Kolikonda is present, is it not? Yes, Kolikonda is present, and I can drag it. Yes, our Kolikonda Sharad Babu. Now the switch over to the first question in the mixed multiple choice questions, right?
Yes, sir. The first question is rights given by natural law which cannot be taken away, transferred, or denied. A. Fundamental rights. Option B. Inalienable rights. Option C. Customary rights. Option D. Statutory rights.
A, sir,
Option D.
fundamental rights.
Option
Any
D.
other option?
Statutory
Option
rights.
B is the correct answer. Inalienable rights. Inalienable rights. They cannot be taken away by anyone.
Nor it can be waived.
Yes, nor it can be waived. Second question, dash view the law as a science, believing that legal decisions should be reached in as much the same way a scientist or mathematician reaches conclusions. A. Naturalists. B. Realists. C. Formalists. D. Positivists.
Option B. Realist.
Any other option?
Option D. Positive.
A, sir. Naturalist.
Naturalist.
No.
A, naturalist, sir.
It's positive, sir.
D.
Option C is the correct answer. Formalists. They view the law as science. Third question. One of the following is not source of law. A. Religion. B. Custom. C. Habits. D. Judicial decisions.
C, habits.
C is the correct option. Habits. That is not the source of law. Fourth question. A person to have his mother's keys in his pocket is said to have A. Lease. B. Bail. C. Ownership. D. Possession.
Possession. Option D.
Option D is the correct answer. Possession. Now, fifth question is, incarceration is A. Civil sanction. B. Criminal sanction. D. Administrative sanction. D. Legislative sanction.
Option D. Legislative sanctions.
No.
Incarceration. Class, I don't remember this.
Shoot. Doesn't
Sir,
matter.
option B, sir.
Criminal, sir. Option B.
Yes, option B is the correct answer. Incarceration is nothing but imprisonment.
Yeah, yeah.
Sixth question. All fundamental rights except dash can be suspended in emergency. A. Article 19. B. Article 21. C. Article 20 and Article 21. D. Article 18.
Option A.
C. Option
Wrong.
C.
Second option.
Is the correct answer.
Option
Article
C.
20 and Article 21, they cannot be suspended in the period of emergency.
Yeah, cannot be
Now,
carried.
seventh question.
Confused.
The Sarkaria Commission is related to the A. International relations, B. Central state relations, C. Judicial and administrative relations, D. Judicial and legislative relations.
International relations, sir. Option A.
No?
Central and state relations.
State relation.
Yes, option B is the correct answer. Central and state relations. Sarkaria commission, that is very renowned commission. Eighth question. One of the directive principles of state policy, which has later become a fundamental right, according to Article 21A, is A. Right to information, B. Right to higher education, C. Right to education, D. Right to pollution-free environment.
Option
C,
A.
sir.
Right to education.
Right. C, sir.
Option C is the correct answer. Right to education. It was first in the directive principles of state policy, and then it was made into fundamental right according to amendment, and that is article according to Article 21A. Ninth question. International law is the legal system governing the relationship between nations. More modern, the law of international relations, embracing not only nations but also such participants as international organizations and individuals. It is according to A. Black Laws Dictionary, B. Oppenheim, C. G. Stark, D. Austin.
Option C. G. Stark. A.
No? Any other option?
Option B, sir.
Not correct. Option A is the correct answer. Black Laws Dictionary. It is available in libraries, especially in law colleges. One can go through it.
Continue.
May 2012, C on 22nd May 2013, D on 22nd June 2013.
Your option
On
C,
22nd
22nd May
May 2012.
B. Option.
C.
Option B is the correct answer on 22nd May 2012. Okay.
Yes, sir.
Yes.
Proceed.
Now 11th question. For every act after enactment, dash must be framed for implementation. A. Directions. B. Procedures. C. Rules. D. Guidelines.
Option B.
rules.
Procedures.
C rules, sir.
Procedures.
C. Rules. Option C is the correct answer. Rules must be framed.
Okay.
12th question. Agreement by way of wager or void, and no suit shall be brought for recovering anything alleged to be won for any wager or entrusted to any person to abide by the result of any game or other uncertain event on which any wager is made. This is A. According to Section 31 of Indian Contract Act 1872. B. According to Section 32 Indian Contract Act 1872. C. According to Section 33(2) Indian Contract Act 1872. D. According to Section 31(1) Indian Contract Act 1872.
So option B, sir, according to section 32 Indian Contract Act 1872.
Wrong.
Second option.
Second option.
Sir, option D, sir.
No. Option A is the correct answer. According to section 30, clause 1, Indian Contract Act 1872. 13th question. A. Answer. Option A is the correct answer for this. 13th question. The number of schedules in Companies Act 2013 is A. 6, B. 7, C. 8, D. 9.
7, sir. Option B.
Yes, option B is the correct answer. The number of schedules in Companies Act 2013 is 7. 14th question. Which section deals with the appointment of auditors? That is in the Companies Act 2013. A. 138, B. 137, C. 139, D. 145.
137, sir.
Wrong.
Wrong.
138.
Say loudly.
138, sir.
Appointment of auditors in Companies Act. The question should be lengthened, but I have forgot. Which section deals with the appointment of auditors in Companies Act 2013?
139, sir. Option C.
Yes, option C is the correct answer. 139. 15th question. There are dash sections of Indian Companies Act 2013. A. 455, B. 460, C. 465, D. 470.
470, sir. Option D.
Yes, option D is the correct answer. There are 470 sections in Indian Companies Act 2013. 16th question. Who was the father of trade union movement in India? A. Sripada Amrita Dange, B. Narayan Meghaji Lokhande, C. Mahatma Gandhi, D. Bal Gangadhar Tilak.
Trade union movement.
Sir, Mahatma Gandhi.
No?
Right.
Raji Lokhande. It's option B, sir.
Yes. Option B is the correct answer. Narayan Meghaji Lokhande. He was the pioneer of this trade union movement and so is the father of Indian trade union movement. 17th question. The first workers' strike in India took place in A. Nagpur in 1877, B. Mumbai in 1877, C. Kolkata in 1877, D. Ahmedabad in 1877.
Kolkata, 1877. Option C.
Wrong.
Sir, Ahmedabad, D.
That is also not correct.
It's
Then Nagpur.
Bombay, sir.
Yes. Option A is the correct answer. Nagpur in 1877. The first official strike of workers took place in India in Nagpur in 1877. 18th question. The earliest Indian statute to regulate the relationship between employer and his workmen was A. Factories Act, B. Industrial Disputes Act, C. The Trade Dispute Act, D. Apprentices Act.
Option A, sir. Factories Act.
Wrong.
So
B,
industrial
sir.
dispute sector.
Industrial
Not
dispute.
correct.
Option B.
No.
Trade Dispute Act.
Yes, option C is the correct answer. The Trade Dispute Act. It was the first Indian statute. 19th question. Voluntary non-fit injuria maxim does not apply was decided in this case. A. Sandstorm versus Colonel Horse. B. Haynes versus Harwood. C. Wagner versus Intellarco. D. Wagner versus International Railway Company.
Haynes versus Harvard. Option B.
Yes, option B is the correct answer. Haynes versus Harwood. Sir, can you explain, Hussain sir, regarding this case?
Yes, because it's you should not keep the unattended horse on the public way, because the children are naughty. They will try to either throw the stone on the horse or they try to pull the tail of the hairs of the horse. At that time, the horse will be startled and it will go haphazardly on the public highway. When a policeman from the police station saw it, and if he could not stop it, he could run over by a mother and a child on the road. So he came forward as a hero and stopped the horse. If he could not do so, at the time the horse run over by the mother and child and got the injury. That means an immense danger is there at the time, and hence he came to the rescue. In all rescue cases, voluntary not fit injury is not applicable.
Yes, that's I want to know. Yes.
Is it clear?
Now, 20th question.
Yes, sir.
Yes, sir.
Yes, sir.
Now, 20th question is the Act number of Patent Act 1970 is A 29, B 43, C 50, D 39. The Act number of Patent Act 1970.
We discussed it.
Yes, sir. 29.
Yeah, shoot your answer.
Option
There
A,
is
a-
sir,
Option B.
29.
Option
D, sir.
A,
Option D is the correct answer. 39.
39.
The Act number of Patent Act 1970 is 39. D. Option D.
Yes, it
Okay,
is
sir.
my turn now. It's the PG-Last 2022 conducted by the University of College of Law, Hyderabad, Usman University. Oh, this multiple choice information technology, why it has come? Because it's a mixed one, we have to deal it. Yes, Amna Shida, no problem. I already fixed over here. MCQ SVM, MCQ yes, MSH. It is present. Oh, this is, how could, no, I clicked the wrong way. I say save. Then I made it, this is a two-way. I think I made a mistake. I put the two names for the same person, for you. I did not, yeah, it is here. So it's a mixed MCQ. And first question, who said jurisprudence is the eye of law? A. Locke, B. Bentham, C. Option Hobbes, D. Lowski.
Lawski.
Lawski, sir. Option D.
I dragged
Yes,
it, I could not make it out. Okay, doesn't matter. Please keep in the mind.
His complete name is Harold Lasky.
Yes, you are right. So it's the J. Lawski, I think John Harold Lawski it seems. Jurisprudence is the eye of law. Jurisprudence is like an eye.
Yes, yes.
It's comparison with the eye. The eye are one of the most important parts of the human body. Without eyes, we can neither see nor do something. This is the reason that jurisprudence is the eye of law. Is it clear? Say yes.
Yes, sir.
Second question. What is dharma in jurisprudence? Which one is not correct statement? I said not correct statement. A. According to Hindu script jurisprudence, dharma means duty in various contexts. B. Option. This could mean either religious duties or even a social, legal, and spiritual duties. C. Some people also use the word to mean righteousness, which gives it a realistic interpretation. D. All of them.
Sir, all of the above, sir. D, all of the above.
Not correct.
Check
Not
again.
correct, sir.
Check again.
A, sir.
Okay.
Check again.
A, sir.
C, sir. Option C.
No, you have to give the answer. Why it is
Yes, sir.
wrong. Some people also use the word to mean righteousness, which give it a realistic interpretation. Answer is, it is not a realistic interpretation, it is a moralistic interpretation. Is it clear?
Yes, sir.
Some people also use the word to mean righteousness, which gives it a moralistic interpretation, not realistic interpretation. Realistic means reality. Moralistic means based on morals. You are not supposed to eat biryani, Hyderabad biryani, when your neighbor is starving for the death. Is it clear?
Yes, sir.
Yes. Third question. Which statement is correct statement? I say correct statement. A. Civil law includes a number of aspects which may be grouped under 6 or 7 major headings, such as the family law, the law of property, the law of tort, the law of contract, the law relating to commerce, business, labor law, law of taxation. B. Family law governs marriage, divorce, maintenance, custody of children, adoption, inheritance, and succession. C. The law of property includes right of ownership transfer, sale, mortgage, lease, trust, intestacy, and similar matters. D. All of the above.
All of the above.
All of the above, sir.
Check again.
Option A, sir.
No,
Option B.
all of the above is the right answer.
Yeah.
Yes. What are the properties that can't be transferred in as per the Transfer of Property Act? Which one is false statement? I say false statement. A. An easement cannot be transferred apart from dominant heritage. B. All interest in property restricted in its employment to the owner personally cannot be transferred by him. C. Even a right to future maintenance in whatever manner arising secured or determined can be transferred. Then all of the above.
Sir, option A, sir, means easement cannot be transferred.
Do you know what is
That's
meant by
right.
easement?
Yeah, means free
Yes,
passage.
sir. Free passage, yes.
Suppose if you bought the cow, if it is hung the calf, automatically calf comes with the cow.
Oh,
Yeah.
Okay, the first one is correct statement. Except the dominant heritage. All interest in property restricted in employment to the owner personally cannot be transferred by him. It is also correct statement. Then what is left? Even a right to future maintenance in whatever manner arising, secured or determined, cannot be transferred. Future maintenance cannot be transferred. Is it clear?
Yes, sir.
So statements
Yes, sir.
are very much important. Unless until you are thorough enough, then only you can do it. See, this technique also I am giving you. What are the 4 elements of tort? Find the odd man out. A. The accused has a right in most personal injury cases to act in a way that did not cause you to become injured. Option B. The accused committed a breach of the duty. C. An injury occurred to you. D. The breach of duty was proximate cause of your injury. See very closely so that you could understand it.
it's option C, sir.
The accused committed a breach of the duty. Yes, he committed a breach of duty. And with the duty of breach of duty, the injury occurred. And the injury is not proximate. It is very near. In the proximate cause, there are 3 cases are there. Reasonable forcibility does not mean remote possibility. Fordham versus Hardcourt case law, Bolton versus Stone case law, Abrath case law. These are the 3 or 4 cases are very important. I repeat the statement. Reasonable foreseeability does not mean remote possibility. So here the answer is the accused had a duty, not a right. The accused had a duty, not a right. Is it clear?
Yes, sir.
The accused had a duty in most personal injury cases to act in a way that did not cause harm to the injured. For instance, a busy public street. I don't know what is the busy public street, but I can say in the Hyderabad, Sultan Bazaar. In Warangal, Batala Bazaar. What about in Khammam?
Kaman Bazaar.
Kaman Bazaar. In Kaman Bazaar, can you go open the umbrella, the style that you want to go?
No.
It's the duty lies on you to see that it will not harm the other people, the spokes. Even a crowbar also, you cannot go the crowbar the way that you want to take it out. Is it clear?
Yes, sir.
So the
duty
accused
lies-
had a duty, but he had breached it.
Yes. Sixth question. Is burning effigy is a tort? Which is appropriate option? A, it is a tort. B option, it is a slander. C option, it is a libel. D option, it is a criminal wrong. Do you know what's it by effigy or effigy?
Yes, sir.
Yes.
Statue, just
It is like a
statue.
dog framing a person's face, and in protest, they will burn the effigy in four corners of the road to show the protest.
Dishti-bomma.
Yes, in other way. But the distibomma kalchadam వేరు distibomma in the field is different. The distibomma in the field is called
Scarecrow.
scarecrow. S-C-A-R-E, scare hyphen C-R-O-W, scarecrow. So, what is the answer for that one? A, B, C, D? Appropriate answer.
C, sir.
It is a libel. It is a permanent form. You can see with your eyes. Broadcasting is a libel. Effigy is a libel. Caricature is a libel. Cartoon is a libel, which is in the permanent form, where we can see with the eyes. Even a synchronized film also a libel. In a compact disc also a libel. Is it clear?
Yes, sir.
A label is to eye, a slander is to
Ear.
Libel is to the eye and slander is to the ear. And another point also, you cannot call a prostitute as a prostitute, even though it is a true. Because truth is not a absolute defense, it is a relative defense. Okay, seventh question. Which statement is correct? A, public international law is made by the statutes, states for individuals. B, it is based on the mutual obligation and constant ratified by the charter. C, if one state ignores the facets of the international law, then it endangers the standing of the international law, as another state may do the same. And D, all of the above. Yes.
Option C, sir.
No.
If the state ignores, then it endangers the standing of international law.
Is correct is option A, sir. Public international law is made by the state for individuals.
Suppose if I say yes,
Yeah.
what is the wrong there which I committed? I made. It is made by the state. There are two wrongs are there totally.
is made by nations for nations.
It is the state for a state.
Yes.
And that is the wrong, that is one. Then it is based on the mutual obligation and the consent ratified by the charter. No. When the people will make it is not a charter. Charter will be made by the special agency or UN. It is only a treaties. So the B is also wrong. Is it clear? Then C is the right. But you have to give that answer why C is the right. If one state ignores the facet of the international law, means breaches the international norms or instruments or articles, then it endangers the standing of the international law, as another state may do the same. So the state will be very much strict and the sanctions should be there. Is it clear?
Yes, sir.
Yes, sir.
Another point. The states or nation makes the treaties, or the UN and special agency will make the charter. There are two ways we can make the international instruments. Okay, next, eighth question. When did India join in UNO? 30th October 1994, B, 30th October 1945, C option 30th August 1944, D option 30th August 1955.
1955, I guess. So where is the question, sir?
When did India join in UNO?
Sir, option B, sir, 30th October 1945.
When the UNO is formed?
47.
24th October 1945.
30th October 1945. And the first charter is Universal Declaration of the Human Rights. It is a mother of the
the yellow.
human rights.
1972.
Then the right answer is
Sir, UNO was formed on 24th October 1945.
but the
But
India
India
joined
joined, I think.
30th October 1945 is the right answer.
Yes.
So capability, as the Kolikonda Sharad Babu told, when the UNO is formed and when the India joined, and how many members are there in the UNO right now? How many observer states are there right now? These are all the supplementary questions. And which is the smallest state in the world? Vatican. So, October 30th, 1945, India is a founding member of the United Nations. On June 26, 1945, India was among the 50 countries to sign the UN Charter. India joined the United Nations after ratifying the UN Charter on October 30th, 1945. Ninth question. Defendant was not principal or agent, thus was not bound by the contract, was observed in the case of dash. In other words, there is no privity of contract, was observed in the case of. Both the way it can be asked. There is no privity of contract observed in the case of, or defendant was not a principal or an agent, thus was not bound for the contract, was observed in the case of number 1. Dunlop Pneumatic Tires Company Limited versus New Garage and Motor Company Limited. B. Dunlop Pneumatic Tire Company versus New Garage Motor Company. And Dunlop Pneumatic Tire Company versus Selfridge and Company Limited. D. Dunlop Pneumatic Tires Company Limited versus Action Grayshaft for Motor Unit and Morzafekun Bamboo, something it is there, and Farm Cordell and Company.
Sir, it should be CISA, I guess.
Because
difficult to remember.
other things you never heard it, except
No,
Dunlop Pneumatic Tire Company Limited versus Selfridge Company.
Selfridge.
The reason is
Yes, sir.
the car which you are selling by the Dunlop, it will be changed. It should be made with the Duke company, but the Selfridge company has made it. But Selfridge company is not having the contract with the Dunlop Pneumatic company. And a Dunlop Pneumatic company cannot file a suit to the party who is not the party to the contract. I repeat, Dunlop Pneumatic Tires Company should not file a case to the party which is not party to the contract, because Duke company is the party to the contract and is a third person. So that was the case line, the contract. Okay, 10th question. Which one is the wrong statement among the 4 statements? A. Worker means a person employed directly or by through any agency, including a contractor. B. With or without the knowledge of the principal employer, whether for the remuneration or not. C. In any manufacturing process or in a cleaning any part of the machinery or premises used for the manufacturing process, or in any other kind of work incidental to, or D. Connected with the manufacturing process or subject of the manufacturing process, but does include any member of the armed forces of the Union.
Option D, sir.
It is true, but you have to tell me why it is.
Means armed forces cannot be part of a manufacturing
Yes,
process.
that is a technique you have to use it. That what I did is, no, I removed the does not, but does not include any member of the armed forces of the Union. I made, but does include the any member of the armed forces. So such a technique you have to observe. See, the technique you observed over there, because generally you know that armed forces will not come under. Is it clear?
Yes, sir.
So that is the technique that is called deductive method. And this is the first time, even myself also, I don't know this question. This is the first time I came to know this question. The 11th question. Dudley and Stefan, both are the defendant, and another person also there, and his name is Brooks. And these 3 people, when the wreckage is there, they killed a person whose name is Parker. And they said, we killed the Parker because the necessity made us to kill him, because we starved to death. And Parker is the minor, very engaged fellow. That's why we 3, of course, 2 are directly took the part, but Brooke did not take the part. but they killed the parket and ate the flesh, human flesh. Now, what is the right case law? Exact name of the case law. R versus Dudley and Stephens. B. R versus Dudley, Stephens and Brooks. C. Rex versus Dudley and Stephens. D. Regina versus Dudley and Stephens. What is the exact name of the case law? Even myself also
option
did
A,
not
sir.
know. Today I only came to know.
Option B, sir.
Sir, if I guess, I'll go for A, sir.
B. Option B, sir.
Read. I say read.
I read it only A, sir. R versus
Even
Dudley and
myself also, R versus Dudley and Stephens, I read it total 32 years.
Yes, sir.
But today I came to know it is not the right name. The right name is
Then it must
Regina versus Dudley and Stephens. In Latin, what Regina means? Queen. R means Rex, king. Is it clear?
Yes, sir.
So what is the right name of the case law?
Regina versus Dudley and Stephen.
You can ask your seniors. It is an open challenge. It's an open challenge that you ask your seniors, what is the R versus Dudley and Stephen case law? And ask them what R stands for. Of course, if you ask them, they will say R stands for Rex, king. R stands for Regina, that is a queen, Queen. Today I came to know it is R is not, otherwise I was also in the same impression, R versus Rex. Is it clear?
But if it
Yes,
is
sir.
not there, you can certainly go for R. If
Definitely.
Regina is not there,
If a Regina
then you
is
can
not there,
go for
everybody
R
go for the R
versus
versus Dudley and Stephens. And that is the
given, you have
self-interest,
to opt for D.
self-acquiring. That's why I told you, if you teach free, voluntarily, you are not only teaching them, you are learning them also new things.
Hello.
Yes, sir.
So that is my slogan, Anni Dalamulla Kanna
Vidyadanam.
Vidyadanam.
Minna. So hell, yes, it is a murder. Stephen and Dudley to be sentenced to death. The necessity of hunger does not justify larceny, let alone murder. Stephens and Dudley choose the weakest and the youngest to kill, and it was not more necessary to kill him than any of the other grown men. They should not say, for the necessity I killed him. Necessity you can make him in the self-defense. Suppose if I don't kill him and he will kill with his revolver, and hence I took the revolver and killed him because in the self-defense. But the proportionate force should be there. Suppose if a person is having a hand to blow you, you cannot chop off his hand with your sword. If you say that, sir, he's going to strike me, punch me, that's why I chopped his hand. Is it a defense? Is it a necessity to protect yourself?
No.
Answer
A
no.
reasonable force should be used.
Proportionate force.
Reasonable force should be used to defend
Proportionate.
even yourself.
Not reasonable force. Proportionate force should be used over there. Is it clear?
Yes, yes.
Suppose he is going to throw a stone on you and he is in a upstairs or 7th floor or 6th floor and you are in down floor. At that instance, what is the proportionate? Either you can take the stone and throw him very straight way, or you can use the catapult. Do you know what is catapult?
Yes, yes.
Guler in Telugu or Urdu I will say. You can use it. That is a proportionate. Can you use AK-47?
No.
That is not a proportionate. So these are
When
the
a
things which
thief
I want to share
tries
with
to
you.
enter our house also, we should not shoot him.
And moreover, you can keep the broken pieces on your wall. You can keep spikes on your wall, boundary wall. You can keep live electric wire on the wall. But when you keep the live electric wire, you have to put the dangerous symbol. What is the dangerous symbol?
Skull.
A sign. Appropriate
Skull
word
with
is
two
sign.
bones.
Yes,
Yes, sir.
Same
Skull
with
with
cross-
Skull
bones.
with
cross
two
mark.
crossed bones.
that is exactly one skull and two crossed bones is the sign of danger. So that's why we have to keep it in that way. So with this, we would like to stop out. At any time it can be stopped because time is up. And if you want to ask any questions, you can ask me. And tomorrow you can be relaxed and you can see my earlier even YouTube
Videos.
videos also. So you can send us the feedback of yours individually to us because I told you that you can take the screenshot and I'm sure that somebody has taken the shot of the student attendance today. Sir, we may have forgotten, sir. No, sir, you have taken, sir. Okay, I feel very happy if you have taken it. And you can take the screenshot of our three hosts and we are the other two are my ex-students and they are pursuing law but Kolikondai from the USA he dealt it and the Motamari from the Khammam he dealt it and I am from
You're from Tanzania.
I want to know that participant should say
Yes, sir. Tanzania, sir. I've seen your photos, sir. Excellent, sir.
yes but I am
Sir,
actually born in
excuse me, sir.
Kottagudem Ellandu Kottagudem Boguta Kottagudem I born and
God
brought
bless
up
you.
over there up to BSc, MPC, Telugu medium. Yes, anything you would like to
Excuse me,
ask?
sir.
Anything you want to contribute? And
Sri Vidya,
Kolikonda,
thanks
you
for
can
giving me this
deliver
opportunity.
your practical experience regarding the exam.
Sir,
Again, sir.
through this platform, I want to wish all the best for the candidates who are going to appear for the PG law set. And I wish our students must come through flying colors, topping the merit list. At least some of, not some, all of the participants must figure in the toppers list. I wish them all the best, sir.
Thank you, sir.
Motamari, give the
Thank you very
tips.
much,
Thank
sir.
you so much.
Thank you very much.
Full
We'll try to
score.
come up to your expectations, sir. Thank you very much, sir. Thank you
Yes,
very
sir.
much.
I thank you, sir, for giving me this opportunity. And I wish all the students for their PG Law Set exam. I can only say that concentrate on much on jurisprudence and constitution as it contain much weightage. Later on, you can see the rest part. And all the best, all of you. Thank you, sir.
Thank you, madam. Thank you, madam.
Still, I don't
Uh,
know. The Cisco WebEx is kind enough today. It is not closed. Anyway, that the tips, as you said,
Hussain
no.
sir, Hussain sir, I want to thank you a lot for giving me this opportunity to meet the students along with you and contribute myself towards this program, PG Law Set. Earlier also I have been part of you, but first I didn't think that I would be a part of this program, but you have pressurized me and I have pleasantly accepted it. And I had to prepare a lot the whole day during these 11 days. And thank you very much for enriching my knowledge also. Thanks a lot to Sri Vidya also.
My motto is the
Thank you,
knowledge
sir.
should not die with a person. Actio personality is maricum persona. A personal action should not die with a person. That's the law of thought. So that's why I would like to share it. Because when I was sharing it, I came to know, even 32 years I did not know what is R stands for. And this opportunity, and don't say every time opportunity, for giving the opportunity. No. The style of the Professor Hussain is giving this slot to me, slot, SLOT slot. Very few people could use such a word. And everybody then, for instance, you can give me, I don't say the opportunity. I will say, I'm very much thankful to the management who has given me the slot to promote myself or use my knowledge. SLOT. Please try to use the other word also.
And this online test is also not that big challenge, sir. First, I wish all the candidates to go through the guidelines, and they should not be in a hurry. And the clock will be clicking on the screen. I think they have already paid for such examinations. So
But
this
still, you
time
can do
also
the
it won't be
tips.
so hard. It won't be so hard. And don't be in a hurry to answer, and please first go through the easy questions, and then in the hard, then go for the hard questions, so that after submission you cannot go back to the already answered questions. So I hope everyone will know these guidelines and
After
follow.
we can go back.
Tanzania